Hello, and thank you for joining us for today's webinar. Before we get started, I have a few housekeeping notes. For the benefit of all participants, attendee lines have been muted. Should you have any questions that you would like to submit during the event, you may submit them through the chat box at the bottom of your screen. If we cannot address your question during today's webinar, we will follow up after the program. Please note that today's webinar will be recorded and circulated to all registrants via email after the event. Should you have follow-up questions at that time, please reach out to any of the key contacts listed in the email communication. Note that Dentons can only issue CLE credit for attendance during the live broadcast of the webinar. The following is a very important message regarding CLE credit. The webinar window must remain open for the entirety of the program, and it must be the only window on the forefront of your screen. WebEx will detect if you minimize the program or use the computer outside the webinar software, and this will prevent your earning CLE credit. One other important note, if you have a New York or New Jersey license, please be sure to listen for the code word given during the program. When prompted, you will need to enter the code word into the Q&A section of the screen. If you don't have a license in these states, you can disregard that. And now I'm going to turn it over to our presenters.
Great. Thank you so much, Casey, and good morning and good afternoon, everyone. I'm Peter Stockberger, San Diego Managing Partner at Dentons, and with me is Sam Kulari, partner from our Washington, D.C. office, and Jacqueline, a Managing Associate from our New York office. And we are going to be discussing today what we're calling the known unknowns, gray areas of the expanding U.S. privacy law landscape. So a little bit of what we're going to be digging into today, we're going to dive into some of the more complicated and tricky areas of compliance in what is now a growing patchwork of U.S. state privacy laws. We've added a new state as of yesterday. Connecticut joined the party. So we're going to give you an overview of what these U.S. state privacy laws in California, in Virginia, Colorado, Utah, and now Connecticut. And then we're going to jump into the more complicated areas of compliance: data protection assessments, digital ads and tracking, collection and processing limitations. And of course, because California, we always do things differently, we'll dive into a couple of California nuances. At the end, we'll provide some key takeaways and questions at the end. Also, there's a Q&A box in the portal here, so you're free to type in a question throughout, and we'll answer them as we move along in the agenda. But to kick things off, I think it would be helpful to sort of set the table on what are these new U.S. state privacy laws, and then we'll jump into, well, what are the more complicated areas of compliance? And the reason why we're focused on the gray areas today is because the rights and the privacy policy obligations and the notice obligations under these laws are pretty well trotted at this point. It's well sort of accepted knowledge. There are some pretty clear black and white requirements under these laws. But the gray areas are where we're finding our clients find real challenges in implementing and rolling out operational compliance. So that's what we're going to sort of dig into. Before we give you an overview of the current U.S. state privacy landscape, we thought it would first be helpful to give you this snapshot of U.S. privacy law more generally. As most of you know on this webinar, there is no federal U.S. privacy law. Historically in the U.S., privacy law has been highly sectoral, both at the federal level and at the state level. So at the federal level, we have things like the FTC Act that governs unfair business practices. So you can't say something in your privacy policy that's false. That would be unfair business practices. That's enforced by the FTC. We have COPPA that regulates the collection of minor data. You have GLBA and other financial privacy laws, and the HIPAA framework around federal healthcare privacy laws. The state level is where we're seeing most of the action. All 50 states have their own data breach laws. Many states have sister counterparts to the financial and healthcare laws at the federal level. But the laws that we're seeing the most development in are in this bucket of consumer privacy laws. Those are these omnibus state privacy laws that are really becoming a patchwork of obligations throughout the 50 states. And that's what we're going to be sort of diving into today. So I'm going to kick things off and just give a brief overview of the California landscape. and then I'll toss it over to Sam to dive into Virginia and Colorado. In California, the current effective law is the California Consumer Privacy Act. It took effect on January 1 of 2020. It's been enforced by the California Attorney General's office since July 1st of 2020. This is the maiden ship of state consumer privacy laws. It was the first of its kind in the US. It introduces broad consumer rights for most California residents, imposes very particular obligations on businesses, such as notice and privacy policies and needing to respond to consumer requests. You'll see as a trend with all of these laws, there's a very limited private right of action in California for negligent data breach. Otherwise, the rest of the law is enforced by the Attorney General's office. Just a brief note on who's covered under the CCPA. Well, you've got to be for profit. You've got to be doing business in California. You've got to be collecting California resident information, and then meet one of three thresholds. You either have annual gross revenue in excess of 25 million, you collect the information of 50,000 or more California residents annually, or you derive 50% or more of your gross annual revenue from selling their data. There's a second definition around parents and subsidiaries, but that's the core definition that'll get you covered. That's the law as it stands today. That law is being amended effective January 1 of next year under what's known as the California Privacy Rights Act. That will be effective January 1 of 23, enforced beginning in July of next year by a new enforcement agency called the California Privacy Protection Agency. And Sam and I were just joking before the webinar that it would be great if somebody could come up with a different set of letters for both these laws and the agencies, because we're having an acronym word salad. But the CPPA will enforce the law beginning in July. Regulations are forthcoming and are being drafted, and you will be covered under the CPRA, similar to the definition under the CCPA, but one of the key differences is it goes from 50,000 to 100,000 on that second threshold. So that's a very high-level snapshot of the California landscape. And with that, Sam, I'll toss it over to you to dive into the second state on the hit parade, and that's Virginia.
Thanks, Peter. Hi, everyone. Sam Caleri. As Peter said, Virginia was the second state to adopt a comprehensive consumer privacy law. It's the Virginia Consumer Data Protection Act, or CDPA, continuing the acronym alphabet soup. It was passed in March of 2021, goes into effect like the CPRA, goes into effect on January 1 of 2023, and will begin enforcement on 7/1/23. Covered businesses are those that process 100K residents data annually, or process 25K annually and derive 50% of their revenue from selling personal data. Unlike the CPRA, they did not add the sharing piece into their definition. There are many parallels between the CDPA and the CPRA, but there are some differences. One of them is here in the covered businesses piece. There is no standalone revenue threshold for Virginia businesses. There are also in the CDPA broad consumer rights and business obligations, much like the CCPA, but they also added some data security requirements, as well as data protection assessment and data minimization requirements, which Jackie will talk about in a little bit. Some of the rights that are available to Virginia citizens are the right of access, correction, deletion, portability, and the opt-out of sale and use of personal data for targeted advertising.
Sam, one known unknown gray area about Virginia, and I think also Colorado, and Jackie probably on Utah and Connecticut, that I think you're going to talk about, is this 100,000 or more resident threshold. When you read the statutes, they're a bit different from California in that California talks about the collection of 50,000 or 100,000. But these laws, Virginia, Colorado, Utah, and I believe Connecticut, talk about the processing. And that really can include storage. So if you've like historically collected the PI of people from Utah, Virginia over the course of the past 10 years, and you're sitting on that data in a database, even though you don't have 100,000 or more new customers, you can get brought in under this law. And I think that's sort of an interesting gray area that will hook in a lot of businesses that otherwise may think that they're not covered.
Yeah, I think that's right, Peter. And with the lack of the standalone revenue threshold, there will be some businesses that may not be captured, but because of that definitional difference, there are other businesses that will. So still a really broad swath of businesses that would fall under this regulation. So for Colorado, the Colorado Privacy Act, they got really creative there with their name. It was passed in June 2021. Unlike the others, it goes into effect on July 1st of 2023 rather than on New Year's Day. And in many ways, including in the businesses that are covered, the types of businesses that are covered and thresholds, Colorado is nearly identical to Virginia. There is no private right of action. There is no private right of action under Virginia either. It is the Colorado Attorney General, and like in Virginia, the Virginia Attorney General that will be enforcing this law. And the regulations for Colorado are yet to come. But like Virginia, Colorado has the same access rights. They have access, correction, deletion, portability, opt out of sale, and use of use of data for targeted advertising. So with that, I'm going to pass it off to Jackie Lefebvre to talk about Utah.
Thanks, Sam. So Utah was the fourth state to adopt a comprehensive consumer privacy law. It will be effective December 31st of 2023. Somewhat similar to California, the UCPA, at least we have one that's not starting with C. It applies to nonprofit entities that you're either conducting business in Utah or you're targeting Utah residents. You have an annual revenue of at least 25 million. So there's that revenue distinction. And then you're either meeting one of the two thresholds. So you're annually processing personal data of 100 or more Utah residents, or you're deriving 50% of gross revenue from the sale or processing of personal data of 25,000 Utah residents. The UCPA, it adopts a controller processor framework, so that's similar to the EU's GDPR, and we also see that in Virginia and Colorado. I'd say probably the UCPA mostly resembles Virginia privacy law. There are a few notable differences. With Utah, there is a narrow right to delete, so it limits the consumer's right to delete personal data to any data that a consumer has provided to the controller. So that's a little different there. The UCPA does not give consumers a right to appeal a denial of their request or their exercise of their rights. Also, we'll be covering this later on in the webinar, but Utah also doesn't require data protection assessments. So that's a notable difference as well. And then also with sensitive data, Utah mirrors, it's similar to CCPA requirements in that controllers have to, or businesses have to give consumers an opportunity to opt out prior to processing their sensitive data. With the UCPA, it goes through the Attorney General in terms of complaints, and there is a 30-day opportunity to cure. For those uncured violations, this gives the AG the opportunity to recover actual damages to the consumer, and then also up to $7,500 for civil penalties. And there's no private right of action in Utah.
Jackie, you know, something that you mentioned about the deletion, the narrow deletion right under Utah, it sparked something that I remember from California when the CCPA was being debated and then amended with the regulations in the legislature, is that was the original position in the CCPA and the regs, which was you only have to respond to a deletion request about data you've collected directly from the consumer, which is a much more narrow universe than data you collect from data brokers, from service providers, from vendors, whatever the case is. And California
Right.
decided to expand that. And now you have Utah that narrows it. And I think it goes to a key takeaway that we'll talk about at the end, which is it really feasible to play whack-a-mole here and respond to certain deletion requests from Utah and narrow the request, respond to California residents and have a broad request? Or does it make more sense to have just a uniform 50-state solution where you take the broadest measure, like in California, and apply it across multiple states? So I think that was it's a really interesting nuance, and it shows you how different these laws can be, even though they look very similar on their face.
Yep, that's right. Okay, so Connecticut, Peter, as you mentioned, this is as of yesterday. Connecticut becomes the 5th state now to enact, more of a comprehensive data privacy law, and this is the effective date similar with Colorado. That dates July 1st of 2023. The CDPA, it applies to entities that, again, you're either conducting business in Connecticut or you're, targeting Connecticut residents. And then you're either processing personal data of at least 100,000 residents annually, or you're deriving 25% of your revenue from the sale or processing of personal data of at least 25,000 residents annually. And, similar with a lot of these state privacy laws that we've gone through, there are, it mirrors a lot of the similar obligations and also exceptions to consumer privacy rights. The CDPA requires opt-in consent for the collection and processing of sensitive data. It also allows for consumers to opt out of certain processing, specifically targeted advertising, sale of personal data, automated profiling. So again, similar to a lot of these other privacy laws that we're seeing. One thing to note with Connecticut, beginning in 2025, consumers can exercise their right to opt out with a global opt-out device setting. I know we're going to cover this a little bit later on in this webinar, but that's just something to note there too. And with Connecticut, consumers do have a right to appeal a denial of their consumer request. So similar to Colorado and Virginia there. There is no private right of action for Connecticut. The enforcement is going to rest exclusively with the Connecticut Attorney General. As of now, there'll be a 60-day cure period. That's until December 31st of 2024. But then beginning in 2025, that cure period, it's going to be at the discretion of the Connecticut AG. So we'll see how that unfolds.
Jackie, before we move out of here and go to the next topic, we did have a question that came in about, well, how do these laws apply to data brokers? That was the question that came in. And I think the answer to that is data brokers can very well be covered businesses under these laws and have obligations that they owe to the residents of these states based on the data they have. Some data brokers use publicly available data, and so some of that data may be exempt. But in particular, data brokers have to be wary of the selling of data concept and the opt-out rights that people are provided. So I think data brokers is a complicated area. There's a whole data broker registry law in California. So I think the short answer there is they apply to data brokers, and it can be complicated depending on the type of data that you have. And Sam, sorry, I think I stepped on you. I think you had another point here.
Yeah, I was just going to note that it's a long period before the Connecticut law goes into effect. If it's not going into effect for 2 years, it looks like. Is that right, Jackie? Is it or is enforcement begins on 1/1/25, effective on 7/1/23, but they're not going to start enforcing until 1/1/25? That's interesting. That's a long stretch between effective and enforcement. We haven't really seen that before. We've seen like a 6-month break between the effective date and the enforcement date, but with California and Virginia and the others.
Yeah, I think that 2025 is where there's a difference in the cure period. But as of or until 2020, December of 2024, there's a 60-day cure period.
Oh, okay, so that's when the cure period changed. Got it. Okay, my bad.
All right. Well, I think, that sets the table for everyone on what is the current state of U.S. privacy laws, and it's ever changing, as it changed yesterday as we were preparing for the webinar. So now I think we'll dive into the gray areas. Some of the areas that we have found as we work with clients are raising some difficult questions that are not yet answered by the statutory or regulatory framework. And we'd like to start first with this concept of a data protection assessment. So Jackie, why don't you walk us through sort of what this concept is and how the various states are handling this data protection assessment requirement, which really is a European concept that I think we're now starting to see in the US.
Yep. So, Peter, as you mentioned, I think this whole concept of data protection assessments is really stemming from the GDPR requirement for data protection impact assessments. That's really anytime an EU organization is beginning a new project that's likely to involve, high risk to individuals' personal data. So on the US side, I mean, essentially these assessments, it's a process really to help businesses identify and effectively minimize risks associated with processing personal data. So the purpose here is really, again, to identify and weigh those risks versus the benefits, direct and indirect benefits that flow from processing personal information. And with that, it will help businesses mitigate privacy risks. So you're looking at not just the data collection, but also use, retention, disclosure practices. And ultimately, it will provide a roadmap for improvement and will help businesses be able to, further build out their compliance program. And on more of a kind of an operational or practical standpoint, data protection assessments, it involves, I think at the forefront is really like it's data mapping. So you're looking at your business size, operations, complexity. You're also going to be identifying your data risks. So you're looking at the likelihood and the severity of risks. And you're also wanting to consider really the fundamental privacy principles that we're seeing in a lot of these state privacy laws. So transparency, data minimization, things like that. And then ultimately, you're also going to consider the risk minimization. So certain response procedures, technical and procedural safeguards. But really where these gray areas, I think where this stems from is that the states vary on how these DPAs are, what's required, what triggers them. So I'll start with California, the CCPA, and also actually with Utah as well, which I had briefly mentioned. There's no DPA requirement. With the CPRA, there's no statutory requirement, but the CPRA has authorized the CPPA, a lot of C's, to issue regulations to require businesses. So if the business is processing personal information that presents a significant risk to a consumer's privacy, those businesses are to submit on a regular basis a risk assessment, and that will include, the processing of personal information or sensitive information. And again, that assessment's going to, identify and weigh the benefits versus the risks to consumers and also the business.
Jackie, interestingly, on these regulations for the CPPA, I mean, what the statute is saying to this new regulatory enforcement agency is, hey, you can issue regulations sort of requiring certain businesses to regularly send you these assessments. And practically, I think the way this is going to play out is that the CPPA has administrative enforcement of the law. They're going to be sending notices with no cure period to businesses who are in violation of the CPRA. You're going to show up for an administrative hearing, likely in a conference room that doesn't have windows, if it's any history of California administrative hearings, and there will be an assessment of your compliance or non-compliance with the CPRA. I think out of those assessments, the remediation requirements that the agency may issue is these regulations may give them the authority to say, and by the way, every 6 months, you have to send us a copy of your data impact assessment, your data protection assessment on this particular process that you were not compliant with for 6 months to a year. So it really introduces this sort of complicated administrative law nuance on the California side that is different than, I think, Virginia and Colorado, which I know you're going to jump to next. But I just wanted to add that color around how the California administrative law procedure might impact this.
And Peter, that's something that telecommunications and tech companies who have had to deal with the FCC's CP&I privacy rules and enforcement actions and consent decrees that have come out of violations of that set of rules. That is something exactly as you described, that those are the types of requirements that the FCC's Enforcement Bureau was inclined to put into those consent decrees. So there is a precedent for that with a federal regulatory agency.
Yeah, that makes sense. And I think, Jackie, what you're about to roll out here is Virginia, Colorado, and Connecticut are taking the opposite approach. They're saying, do it as a proactive measure. Build in privacy by design at the beginning. Don't wait for the regulator to tell you that you have to submit one. So maybe, Jackie, you could walk us through what this to me is really sort of the core gray area, because this is an affirmative obligation that's going to require a lot of detailed data mapping.
That's right. And so Virginia, Colorado, and Connecticut, they do have, very similar language in terms of what the requirements are here. In terms of the triggers, like what's going to trigger a business to conduct an assessment, and that's when the business is engaged in targeted advertising, processing of sensitive personal data, the sale of personal data, and then processing personal data for purposes of profiling. With the profiling, it's where it creates a reasonable foreseeable risk of, and then we have a list here of either unfair or deceptive treatment on the consumer, financial, physical, or reputational injury, a physical intrusion of privacy, and then specific with Colorado, if there's a substantial injury to the consumer. And so that's where here there's a little bit of differences in language between these states. For Virginia, it requires an assessment of any processing activities that present a heightened risk of harm. And Colorado defines heightened risk as what we just listed above here, with the targeted advertising, sensitive data, sale of personal data, and so forth. In terms of the substantive requirements, again, these three states are fairly similar in what is required. A business is going to identify and weigh the benefits that flow from processing of the personal data, and that's going to be compared against the potential risks to the consumer. Interesting for this assessment and the factors we're seeing within the language of these state privacy laws is that the assessment must factor in the use of de-identified data, and I think we're going to touch upon that later in this webinar as well, kind of what that means in terms of a factor. And then also reasonable expectations of the consumer and the context of processing and that relationship that a business may have with the consumer. And again, as Peter mentioned, these will be, the assessments would be made available to regulators upon request.
So Jackie, I'll just sort of jump into sort of what these open questions are on the DPAs, but I have two sort of client examples that I think illustrate practically how these DPA questions are becoming sort of complicated. So the easy use case is I have a client who sends out repair folks to people's homes to repair washers, dryers, whatever the case is. And they track their repair people by very specific geolocation data on their device. Specific geolocation data is defined as sensitive personal data under Virginia, Colorado, and Connecticut. And therefore, you would have to conduct a DPA around the use of that specific geolocation data as it relates to tying to the individual homeowner. And I think the answer there is, well, you weigh the privacy risks. I think the benefit to the business outweighs the privacy, arguably in that case, because you have to be able to track to the people's homes, monitor the performance of work, and there's perhaps little privacy risk of understanding somebody's home address. That's sort of use case one, determining whether DPA is required. But then another client of mine is looking at how do you categorize customers into who's paying their bills and who's not? And the people who aren't paying their bills, how do you put them into a category where they're getting more messages or they're getting more reminders? And it's all through automated processing. So they're developing profiles about customers based on ability to pay, location, zip code, perhaps the tendency not to pay their bills, and make predictive profiling about that information. There, going back to your Virginia definition, you could see how if that profile were made public, there is a foreseeable risk of potential reputational injury to that individual. So would you need to conduct an assessment there and weigh those benefits and document that? I think those are just kind of practically things that I've been seeing in the past 2 weeks. And then also one of the big sort of open questions here is, what is going to be the assessment standard for California? What does the CPPA come out with? Is it going to look like Virginia and Colorado? I suspect they're not going to go way off the reservation there. What does it mean to use de-identified data in these risk assessments? And how do you measure heightened risk of harm to consumers? I think those are real sort of open questions because you can see how there's a judgment call to be made. And does that judgment call then introduce express liability for not having record keeping? One of the other gray areas that I see is around, do you have to do it for specific operations or can you do it for processes more generally? Can you say, for example, onboarding of customers is a process? We will conduct a DPA for the onboarding of customers more generally, and not every time we're onboarding a customer, we conduct a separate DPA. I think that sort of question of how frequently they have to be conducted and how broad they can be is an open question. We'll have to see if Colorado in particular addresses these in the regulations. And then one of the final sort of open questions that I have is around retroactivity and around public records requests. So California expressly says the requirement to do a DPA will not be retroactive, going back beyond when the law starts to be enforced by the CPPA. But Colorado is silent on that. So we'll have to see whether the regs sort of touch on that or whether the Connecticut AG touches on it. For Virginia, they've already closed out their amendments to the law, and there doesn't appear to be any additional regulations coming. So I think Virginia, we know what the landscape is based on the statute. And then finally, around Public Records Act, there are some very express exemptions that exempt DPAs from Public Records Act requests, but we don't know if that's going to apply in Colorado and California. And that's, to me, very important because you can imagine where you're required to submit DPAs, very sensitive documents to the regulator, and curious folks, plaintiffs' attorneys, other folks can submit records requests, try to get those documents, and then potentially use them in litigation. And one final question before we jump off these DPAs and jump into advertising. A question came in the chat. It said, other than to assist controllers with their assessment, are there independent requirements for processors to conduct assessments if processing activities performed on behalf of controllers include high-risk activities? And the answer there, based on the language in the statute, is the duty to conduct a DPA is on the controller. So if you are only a processor and you are not otherwise independently a controller with regard to data, then your obligation to conduct the DPA under these various state regimes would be dependent on what your contractual obligation is to the controller. That's sort of my instinct on that answer. It's obviously the devil's in the details around what your contractual obligations are, but these laws really focus on controller obligations versus processor. So I think with that first gray area, we'll jump to advertising and ad tech, and Sam, we'll toss it over to you. And Sam, if you have any additional thoughts on the DPA stuff, feel free to share as well. But I think we can jump into a very hot topic around digital ads and ad tech.
Yep. Thanks, Peter. Digital advertising and ad tech it is the industry that has been most highly affected by the passage of this patchwork of state privacy laws, and there is a lot of gray area surrounding the industry at this point. Online advertising campaigns are basically focused on maximizing the interactions that a business has with consumers who are most likely to buy their products. There's different ways to do that. One of those ways is contextual advertising. Contextual advertising is based on the content of the website itself. So essentially, you assume that people who are looking at that website are interested in that type of product, and the ads that pop up on that website or application would be the same for everyone who goes on. The other type of advertising is behavioral advertising, which is based on the individual's behavior and their tendencies and visitations on the internet and applications. Behavioral advertising requires tracking, right? When you hear about cookies and pixels, these things are they exist because of behavioral advertising. So when we get down to what's happening with these laws and how they are affecting the digital advertising and ad tech industry, all states are talking about what a sale is, and they all have some restriction or ability for a consumer to control what a business sells, what data of theirs a business sells. And with the advent of CPRA and Virginia and Colorado, the ability to not only limit sales, but also limit the use of their data for targeted advertising. In California and in some of the other states as well, they are using the word sharing in the definition as well. This is based off of a tendency after the CCPA was adopted for many businesses to assume that while very broad, the definition of sale under the CCPA would not include third-party cookies on your website or pixels. The CPRA actually clarified that California did intend, and the California AG has said as much, for the use of what should be referred to here as cross-context behavioral advertising is something that they want to regulate. It is something that they do not want consumers to have to be subject to without their knowledge or their ability to opt out of that type of advertising. And cross context behavioral advertising is basically behavioral advertising that crosses over businesses, platforms, applications, services. So you may very well have visited somewhere that is unrelated to a business that is getting data about you and your habits, and then targeting you based on the fact that you visited a car dealership online, and now they know that you may want to buy a little tree air freshener, so they're going to market to you. The CPRA is structured such that it removes cross-contextual behavioral advertising from the definition of what is considered a valid business purpose, and thereby, if you send information to a vendor, and it is strictly for the purpose of utilizing it for this type of advertising, that vendor would not fall under the definition of a service provider under the CCPA or CPRA, which would give you additional protections. They would just simply be a vendor, and you wouldn't be able to avail yourself of the protections, the safe harbor of calling them a service provider. This makes it difficult now for the ad tech industry, which is based off of the use of these types of technology, because there is a duty to provide notice at the point of disclosure, or the point of collection rather, that you are collecting data for a particular purpose, and with the inclusion of sharing and the ability to opt out of sharing for targeted advertising, you would actually have to implement a mechanism that allowed for a consumer to opt out of the use of a third-party cookie or pixel on your website. So that actually would cause some issues. And one of the other things that they're focusing on, the regulators, are what they call dark patterns. Dark patterns are just deceptive, confusing interfaces on the internet that might cause a consumer to do something that they would otherwise not do were they not confused. This leads us into what are the gray areas for ad tech with the adoption and potential enforcement of all of these current regulations and future regulations. And I'll pose these questions and answer them myself with my opinion here. How will a cookieless future impact the digital advertising space in compliance with emerging US laws? I think we're already seeing it. We're seeing major tech companies like Apple and Google restrict or actually completely ban use of contextual advertising on certain platforms. It is going to continue in that direction based on the way these laws are going, and companies are going to have to figure out creative ways to reach their target audiences without the use of these technologies if consumers start to avail themselves of these rights and opt out of the sharing and use of their data for targeted advertising. How will the regulators in California and Colorado further define targeted or cross-contextual advertising? Based on everything we've seen and heard to date, we have no reason to believe that anything that they say will be less restrictive than what we've got in place now. And I think, the third bullet is answered by my answer to the first bullet. I think you're just going to see more companies start to figure out ways to, ensure that they do not have liability based on these new regulatory challenges. The global privacy control. The global privacy control is there's ambiguity around it. The California AG has said, after some folks were not sure about what the interpretation was going to be, that if a company receives a signal from the global privacy control on their website, that they should consider that a consumer's request to restrict sharing of their personal information. I think that this area of self-regulation is something that is likely to continue to develop. I think we'll see more in this area. I think, the global privacy control will probably expand and receive greater adoption in the near future. And then the last question here, will there be a standardization of the dreaded cookie banner? My humble opinion is that's about as likely as getting a comprehensive data privacy bill through Congress.
Sam, which is there not a likelihood of that? I don't understand. Is that a joke? Something about the global privacy control, just to provide some context. I mean, the global privacy control is a signal that people can set right now on certain browsers, like Mozilla in their browser, DuckDuckGo in their browser. They have the ability to set this. And what it does is it puts a signal in the header, the invisible header. When you visit each web page, the header is sort of telling the website what your choices are, what you've selected. And this privacy control is telling the website, I don't want to be tracked. I don't want to be tracked. I don't want to have advertising. So the idea behind it is that you wouldn't have a need for a cookie banner. There would be no need for the choices because the choice has already been exercised to not set those types of cookies or pixels on the individual's device. And I know in California in particular, this is a hot button item for the CPPA right now. The executive director of the CPPA is really the brainchild of the global privacy control. That's what he did before he came over to the CPPA. So it is an area focused. I suspect we will see some language around this in the draft regulations that I believe might come out this month around this issue. So key takeaway here is start thinking about, from a technological standpoint, how could you respond to the GPC? And have those conversations now, because it's going to take some coding. It's going to take some sort of tech thinking through. And I think that's one of our key takeaways is start thinking about the GPC now. Start thinking about moving from third-party cookies to first-party data and how to advance out into this new sort of digital ad tech gray area phase. Before we jump to the next topic on the limitations, we do just want to provide the CLE code word for people who are licensed in New York or New Jersey. The code word is GREY, G-R-E-Y. You can type that into the Q&A box on your screen. Again, the code word is GREY. This is for folks who are licensed in New York or New Jersey to receive CLE credit. And we'll give you a beat to write that down. The word is GREY. All right, with that, Jackie, I want to toss it back to you to talk about another gray area between these state laws, and that is around collection and retention limitations, this new concept of requiring businesses to have a statutory mandate to limit what they're collecting and limit what they're retaining, which was really traditionally a European concept, but now is sort of creeping into these state privacy laws.
Thanks, Peter. And yeah, I agree. I think this idea of setting limitations for collection and retention is, in my eyes, I think it also kind of stems from one of the kind of fundamental privacy principles that we're seeing with these state laws, which is data minimization and kind of, you know, limiting that collection and processing to really what's required to fulfill, you know, whatever purpose that is that you're collecting the personal information in the first place. I know we are starting to run out of time, so I'll just quickly highlight some of the what I see are being kind of the gray areas here. And to me, I think that's really looking at the nuances of the state privacy law, the language within these state privacy laws. I think from first glance, it looks, you know, they all look to be generally pretty similar in what they limit with collection and retention, but I think there are just a few key differences that we see. The CPRA kind of has its own a separate language. In terms of collection, it has to be reasonably necessary and proportionate to achieve the purposes for which the PI was collected. And then data can't be retained for longer than what is reasonably necessary. With Virginia, Colorado, and Connecticut, they more or less have the same language. So collection, it has to be adequate, relevant, and reasonably necessary. And then it, in terms of you know, retention and subsequent use, it has to be again, reasonably necessary or compatible with the disclosed purpose. We have just a little note with Virginia and Colorado, actually with Connecticut as well. There's a slight distinction in terms of the retention limitation, and that is, you know, it has to be reasonably necessary and compatible unless the business has obtained the consumer's consent for processing otherwise. And then with Utah, there's no, and CCPA in Utah, again, there's no set collection and retention limitations. But with Utah, I just wanted to point out there is data minimization is referenced in the statute. And I think what the key difference, though, is that rather than a collection limitation, it's more so that a business needs to specify the purpose for which it's collecting. So again, this is kind of more of the transparency concept, and that's that businesses need to disclose to consumers, you know, the types of personal information that's collected and the purposes for why they're processing.
Yeah, you know, Jackie, I think an important note there that you just raised is the key is the notice, because as broad as you describe why you're collecting information and how long you're going to keep it for, that's going to be the key in determining whether you're in violation of statute. So really it ties back to, the notice really can't be a high level throwaway notice anymore. You got to really think through, are we covering all our potential use cases, and are we covering all our potential retention requirements in these notices? So another gray area that we're going to touch on briefly, and then we'll jump into some key takeaways. And if anyone has additional questions, be sure to pop them in the Q&A box, and we'll try to get to them before we end the webinar here. But another area for gray areas is California, because we love to do things different in California. One of them is a right that is under the CPRA, and that is the right to limit the processing of sensitive personal information. The law says that California residents can tell businesses, don't process my sensitive PI other than for the purpose for which you originally collected it. But there's an important exemption. It says if the business is not using the sensitive PI to infer a characteristic about the individual, the business doesn't have to provide that right or a link to allow them to limit that processing. So what does it mean to infer a characteristic? The statute is silent. We don't know if the regs are going to address this. Does it mean creating a profile about the individual? Does it mean inferring a characteristic that's protected under California law, like race or gender identity? It's really an open question. And I have just seen with clients, there's a real struggle to figure out, are we inferring characteristic? Are we not? Another gray area is around automated processing. The regulations, the statute says the CPPA will have the authority to issue regulations to address a right to opt out of the automated processing of data. But that right is not spelled out in the statute of the CPRA. So what does that mean? What is it going to look like? Is it going to be a European style right to limit automated processing? Will it address all AI processes within a business or just targeted processes that, for example, present a risk of privacy to the individual? So it's a gray area that we're going to have to watch. We talked about the GPC, the Global Privacy Control, and where that's heading in California. And the final gray area is around employee and B2B data. Under the law right now, California employees, job applicants, and contractors are exempt from 90% of the law. They're still entitled to notice under the CCPA. Under the CPRA, that exemption expires, and they will be entitled to the full suite of rights under the law. There are 2 pending amendments in the legislature to continue the exemption indefinitely, or at least through 2026. They're pending in committee right now. We think there will be a hearing on those this month. If those exemptions go through, they likely won't be signed into law until October. So key takeaway here is, in California, you've got to be looking at potentially setting up a full privacy program for your HR function, which requires planning now. I'm working with several clients on this. It's not an easy lift to navigate HR and link up with the privacy function. So those are some California specific gray areas. And I think with that, to round out the webinar, we're going to jump in and provide some key takeaways. And I'll kick it off, and then we'll go around the horn here. I think one important key takeaway, and we've talked about it throughout, about the nuances between the states, is you've got to understand which state you're triggered under, and are you going to apply a whack-a-mole approach for each individual state, or are you going to adopt a uniform US standard based on what might be the most conservative or might be the most progressive approach? That strategic decision should be made now. You got to think about, will you increase market share? How do you use it to leverage your products and services? How can you promote it to employees? Do you adopt an employee privacy program? Those are key strategic questions that I think everyone can start making now, even though these laws don't take effect till next year. Sam, with that, maybe you can jump to the next key takeaway here about sort of your technical needs and understanding what's necessary.
Thanks, Peter. Yeah, and this is an extremely important one as well. You need to understand what your current technical capabilities are. As Peter raised earlier, can you recognize a GPC signal? And what is your plan for digital advertising with the cookieless world, quote unquote, that we are approaching? What are you putting in place in order to maximize your ability to leverage your first party data? Because that's going to be critical for most companies. And what are you doing to make sure that those plans are compliant with these existing laws? And not last but not least, making sure that you have mechanisms in place to effectively respond to consumer rights requests within the allotted time period, which for most of these laws is 45 days. And anyone in a big corporation understands how short 45 days can be.
Yeah, I think aligning those internal policies are critical to start planning now. Jackie, here, we got about a minute left. Jackie, you want us to round us out here with the sort of final 3 key takeaways?
Yeah, so I think increasing data visibility, we've touched upon this throughout the webinar, and that's really, everyone's favorite exercise, data mapping, and taking account of the, not just your data, but the processes in place, people involved, and this is going to help better understand the obligations that are going to be triggered as these new state privacy laws are implemented. I think that brings us also to our the next takeaway, which is to really start now. I mean, there's starting the compliance process and program now is really going to just significantly ease the burden as more actionable guidance emerges in the next coming year with these new regulations. And that also leads us to, this next point is watching the regulatory changes. As Peter noted, these draft regulations, particularly in California and Colorado, they may have a significant impact on the planning with the compliance program.
Yeah, we'll be watching carefully the new California draft regulations that we anticipate coming out soon. Colorado is probably going to be coming out in Q3. So reach out to us if you have any questions or would like to be involved in that process. I think with that, on behalf of Jackie and Sam, we'd like to thank you very much for spending some time with us to talk about these laws. We're available to chat offline as well. But thank you very much, and we hope you have a great rest of your week.